You're a father in Wisconsin, and maybe you just found out that you have a child, or maybe you've been in their life since day one, but legally, you're invisible. And if you're not married to the mother, you do not have rights until you take action. I'm Jeff Hughes. I'm the lead attorney and CEO at Sterling Lawyers, and we have helped thousands of Wisconsin families navigate their family law matter from start to finish. In this video, I will walk you through exactly how to establish paternity in Wisconsin, step by step, so you can protect your rights and build your future with your child. Step one is to understand what paternity actually means in Wisconsin. Paternity is not just about biology, it's about legal fatherhood. Without a paternity finding, you cannot get custody or placement rights. You can't make decisions about school or healthcare. You cannot get access to medical or school records, and you cannot protect your parenting time if things go south. And here's the kicker. Even if your name is on the birth certificate, that does not mean that you have rights unless paternity is established legally. Let me give you an example. We had a client, I'm going to call him Mike for this video, and he was there for the birth of his child. He even cut the cord, and he began to pay child support and support that child informally right from the very beginning. He even took that little boy to daycare every single week. And when the relationship unfortunately ended, that mother blocked all contact between Mike and his son. And because he never filed to establish paternity, he had zero legal standing. So we had to start from scratch. Step number two, choose the right path to establish paternity. And in the state of Wisconsin, there are 5 ways to establish paternity. Some are quick and easy, some not so much. Path number 1, voluntary paternity acknowledgement. That's sometimes called VPA. This is the fastest and the most common way. That is where the father and the mother both sign a notarized VPA form, usually at the hospital or through the county. Once that is filed with the state, the father has legal rights, just as if a judge would have ordered it. That comes with a huge warning, so don't miss this. The VPA does include child support responsibilities, but that does not include custody or placement rights unless you file for that separately. Many dads don't realize this, and they think they're covered, but they are not. Path number 2, acknowledgment of a marital child. If the father and the mother get married after the birth of the child, they can file a form to, quote, convert the child to a marital child. And this gives both parents the same rights as if the child was born during the marriage. Now, this is great if you're getting married anyway, but doesn't apply otherwise. Path number 3, mom and dad can't agree, so they have to go to court. If the mother refuses to sign the VPA, or if the father isn't sure he's the dad, then you will need to file a paternity action in your local circuit court in your county. This is called adjudication, and it is a formal process to establish paternity, and it's usually done with DNA testing. So who can file for this process? The father, the mother, even the child can file, and the state can file through the child support agency. And sometimes, in some cases, a grandparent or guardian can file. And once filed, the court typically orders DNA testing. And of course, this is extremely accurate. If the results show a 99% or higher probability, then paternity is established. And this brings up another story that we had with a client. I'm going to call him Jordan. He filed for paternity when the mother refused to let him see the child after the breakup. She claimed that he wasn't the dad, but DNA tests proved otherwise, that he was in fact the dad. And once the judgment of paternity came through, we immediately filed for custody and placement. Without that court-ordered paternity, Jordan wouldn't even have had standing to ask for placement of his son. All right, step number 4, administrative paternity, or fast tracking with genetic testing. Since 2020, Wisconsin has a non-court option that works when both parents agree and DNA tests prove paternity. Here's how it works. The child support agency orders genetic testing, and if the results show a 99% or higher probability and no one objects, the agency then files the results with the state. And boom, paternity is established with the same legal power as a court order. This process is faster, cheaper, and skips the court hearing, but it only works if no one objects and no other father is legally presumed. Okay, path number 5, know the time limits and the rules. You have until the child turns 19 to establish paternity. After that, it is too late. You have 60 days to rescind a VPA signature if you signed it under mistake or under pressure. After that, you can only challenge it in court, and it is a very high bar. You must prove fraud, duress, or mistake. And the courts, let me tell you, are very tough on these challenges. They are hard to get. And finally, what happens after paternity is established? Establishing paternity is just the beginning. Once it's legal, the father can petition the court for custody and placement. The court can order child support. The father's name gets added to the birth certificate, and the father gains rights to the child's medical and school records. And also, the child gains rights like inheritance, Social Security, and health coverage. But here's what many dads miss. Even after paternity is established, the mother still has sole legal custody unless and until the father goes to court to request that be changed. That is why it is critical to file for custody and placement right after a paternity judgment. If you wait, you can risk being sidelined. But here's where most people go wrong. They establish paternity and they think they're done. But legally, being a dad doesn't automatically mean you get custody and placement. If you want time with your child, you need to take the next step. In the next video, I will walk you through exactly what to do first in a Wisconsin child custody case and what mistakes can derail your rights before the court even hears your side. So let's talk about it.